Hello, brothers, sisters, and friends, and welcome to the Fight Like Hell podcast. This is the official podcast of the National Association of Letter Carriers, the union that represents 290,000 active and retired letter carriers employed by the United States Postal Service. I'm Ed Morgan, and as always, we have our national president, Brian Renfro. Hey, Brian, how are you today?
Hey, Eddie, doing great. Glad to be back on for another episode and talk about a topic that's near and dear to me.
So we're going to be discussing the Article 15, Section 3F, and the Interpretive Step tonight. But before we get into all that, we're working a little later today. We're getting a little penalty time in here. I'm broadcasting from home, and that was because the Executive Council was in session today. Do you want to talk a little bit about the Executive Council?
Sure. So this week we had the council in town. We've had pretty frequent council meetings over the last several weeks, and that's going to continue as we keep prepping for collective bargaining. So they spent the last couple of days working within their collective bargaining subcommittees on the different topics. And then today we're recording this on Wednesday. We had just a normal council meeting where we discussed all sorts of things that are going on with our union. As we all know, it's a really busy time. So it's time well spent over the last 2 days. And that has resulted in us recording here outside of our normal hours, but that's okay. We get it done when we can get it done.
Yeah, just like the carriers.
Yep.
Okay. Over the weekend, or Thursday, Friday, and Saturday, we were in Lancaster, Pennsylvania together at my state's state convention. It was a really good time, a lot of fun there. Do you want to just talk about our members there?
Yeah, it was a great convention. Our membership in Pennsylvania has always been just fantastic. Pennsylvania, I've always thought was an interesting state. I've over the years been able to spend a lot of time there. And Western PA and then over in Philly can be very different in a lot of ways. So it's really interesting to see everyone come together and just their passion for letter carriers and, of course, passion for the Eagles and the Steelers and things like that. But President Paul Rozzi and the executive board, all the branches that attended, it was just an excellent convention. I was honored to have the opportunity to be there and, spend a few hours on, I guess it was Friday morning, talking about all the things that are going on with our union and then having the opportunity to swear in the officers of the state association that night. And then we had a Fight Like Hell rally about crime and in support of the Protect Our Letter Carriers Act that next morning. So thanks to President Rozzi and all the executive board and certainly all the branches and the delegates that attended. It was a productive couple of days. And Eddie, I can echo what you said. I enjoyed it as much as anybody, I assure you.
Yeah. At the installation dinner, got a little crazy there between the Eagles and Steelers fans, but we'll leave that off the podcast.
They got loud, both of them.
Yeah.
I won't say which one was louder, but they both got loud.
Congratulations to Paul Rozzi, President Rozzi, and his new vice president, Sean Gakel, who stepped up as the vice president. I'd be remiss if I didn't talk about Fred Rinaldi, who's the outgoing vice president, president of Reading, Pennsylvania. He's a real mentor. He was a mentor to me and just a real family man, salt of the earth. And just congratulations to him and his journey through our union.
Yeah, no doubt. Congratulations to Fred. And I think you said it perfectly. There's not a better human being anywhere. And, the branch in Reading is very much a reflection of him. And we congratulate him on his retirement. And, Fred's the kind of guy that's had the sort of impact that even after he retires, and I'm sure he'll still be around for whatever's needed, his impact continues because of all the things that he's done over the years. So congratulations to Fred. And Fred, will miss you, but I'm sure we'll get to see you often.
And special thanks to Marco Santiago and his branch there in Lancaster, Pennsylvania, branch 273. And they did a great job hosting the event.
They did. And, I often say this at state conventions, that sometimes the unsung heroes of state conventions and even national conventions is it's the people in the host branch because they end up doing a whole lot of the work and getting very little recognition or credit for it. And Marcos and all the members of Branch 273 did a phenomenal job, from just being welcoming to, handling things day to day. And they made sure that everybody had a great experience there.
And we're coming up on the Columbus Day weekend. By the time this comes out, Columbus Day will be upon us. And that's always the Region 6 rap session. So where's that at this year?
Yeah, this year it's in Northern Kentucky, in Region 6, just kind of across the river from Cincinnati. Region 6 moves it year to year between their three states, Kentucky, Indiana, and Michigan. And when it's in Kentucky, it's almost always there. It's a great location. And you're right, it's become a tradition on that holiday for them. So it's always a pleasure for me to be able to spend the morning of that holiday with them. And I look forward to seeing our brothers and sisters from all over Region 6 coming up this weekend.
Yeah, David Mudd and his office do a great job.
They do. They do an excellent job training. It's one of the larger in terms of numbers of people that attend. They're usually somewhere in the 450 to 500 range. And they, as you said, they do a great job, and they have for a long, long time. They do a great job putting on training and, ensuring that our people get what they need to become better representatives for letter carriers.
All right, let's get into the main topic of our episode today. Article 15, Section 3F, and the interpretive step. And this week we filed or sent letters. I don't know, yeah, they're going to help me with this one because we don't do it a lot. But we sent in 2 letters to the Postal Service, one on the arbitrability of grievances not resolved by the Step B team within 14 days. Mm-hmm. And the other one is the UPS's failure to comply with the NALC award. I think before we get into those, unless you want to just do a broad overview, I think we really need to talk about that particular Article 15, 3F, and the interpretive step, and just try to get a ground before we get into those issues. If you do want to listen to anything about the grievance process, we did a whole episode on it. So if you go into YouTube or into anywhere you listen to our podcast, you can listen you look up the grievance procedure. You can go in and get a background on a grievance procedure if you're not up to speed on it.
Yeah, I think it's better, Eddie, if we sort of start with the process itself, what the interpretive step is. This is a piece of our grievance arbitration procedure that is handled solely at the national level. So, for most of our listeners out there, it's not something that they have direct experience with. It's certainly something they have some familiarity with because they've, over the years, more than likely seen when disputes were initiated or disputes arose. And then, of course, through the materials reference system and contract enforcement, they're going to be familiar with national arbitration awards. They'll be familiar with the Step 4 back in the day, or now what we call interpretive step settlements that are out there. But it is a different type of process. And I think starting with the process itself, and then we'll get into the specifics, as you mentioned, of those 2 disputes that we initiated over the past week.
Okay. So just getting into it, we filed some papers. Is the Postal Service also able to bring up this step?
Yeah. So let's start with what the interpretive step is. Like, okay, why does it even exist in our collective bargaining agreement? So, on one hand, our agreement is, compared to most unions, very well defined. It's a large agreement. It's got a lot of text. The JCAM, the Joint Contract Administration Manual, combined with all the things that are in the MRS. Much of our contract over the years has been interpreted, understanding what provisions of the agreement mean. But from time to time, we have disputes of a national nature arise that are about the interpretation of language that's in the agreement, not necessarily about a dispute over the facts of something that happened locally and how the contract is applied, but what something in the contract actually means. As is the case with these 2 grievances, as we'll get into, that often is generated by the Postal Service taking some action that they either haven't taken before or haven't taken before on any sort of large scale which leads to an interpretive dispute over whether that action violates our national agreement or not. And that's kind of the issue here. But if we go back and look over time, if you go back through the MRS and go all the way back to the 1970s, you'll see decades of what originally this step was called Step 4 prior to the dispute resolution process coming along in the early 2000s. Since then, it's been called the Interpretive Step. And over the years, it's where one party or the other, most of the time, has seen in a grievance that started locally an issue that they believe involves a true interpretive dispute. In other words, a dispute over what language in the national agreement actually means. Again, not necessarily the application of that language to something that happened on the workroom floor, for example. When one party or the other identifies an interpretive issue, there's a process in this step of the grievance procedure called the interpretive step, where either the Postal Service or the union can raise that up to the headquarters level.
So do these issues, like, being a steward, do these issues start out as grievances at the informal A level and move their way through the grievance process, or do they arise in a different way?
Both. Sometimes they do start at the informal A level. I mean, sometimes to be honest, as we've got so much history now, there's fewer and fewer kind of new things that happen. But now and then something new happens that's never been dealt with before, or we negotiate or achieve through interest arbitration new contract language. And sometimes there's disputes about what new language means. So sometimes it does come directly from a grievance that starts locally. Sometimes it's a grievance that starts locally, and as it moves through the process, like is the case for one of these disputes we'll talk about in just a minute, one side or the other brings up an issue related to that grievance that can lead to an interpretive dispute. And sometimes the Postal Service just does stuff from the headquarters level that gives rise to an interpretive dispute. So the short answer is it's all across the board. The idea here is that when it's identified by either party, that we can utilize this process to get an understanding, hopefully by agreement, but sometimes through national arbitration, of what the interpretation and therefore the application of whatever language is in dispute actually should be.
So how do we come up with this decision? Like, who's involved? What processes do we use? Is it just you by yourself, or how are you getting this information?
Yeah, so ultimately it's up to the president, of course. But we have several different entities or individuals that are involved and weigh in. One is very often the issues are first identified and elevated to headquarters for consideration by the national business agents. They often come from Step B teams, or issues arise in regional arbitration hearings, and the national business agent would find out about that and then raise it up to us. Primarily at headquarters, our contract administration unit, which is a group of officers and staff that meet weekly to discuss all sorts of issues related to contract administration. Any potential interpretive issue they would discuss. Often, those discussions are very useful in reaching the right conclusion. They have a variety of experience and perspectives in that room, and that is the primary means where these are discussed. And then ultimately, of course, that they would come to the president to make that final decision. But mainly it's the CAU that's involved. We at NALC are very blessed to have attorneys that have worked with us in collective bargaining and grievance arbitration stuff for decades. So they are pretty heavily involved in the discussions. They don't make any decisions, but they are the ones that ultimately, should these things proceed to national arbitration, are the ones that would advocate the cases. So it's very much a group effort. Ultimately, again, the decision is made by the president, but the CAU is a huge piece of that, along with our attorneys. And then sometimes, we discuss issues depending on what the issue is with that specific NBA, about the facts of an issue, sometimes with the executive council, but always the contract administration unit is involved. in these types of discussions and making decisions on, sometimes it's to move forward, sometimes it's not to move forward. Sometimes it's to take a different course of action as opposed to initiating an interpretive dispute.
With this next question, I was kind of thinking about The Office and Michael Scott, and I declare bankruptcy. But like, what does this notice of interpretive dispute letter have in it?
Yeah, it's basically just a letter that says that the JCAM, you have to forgive me, it's in Article 15. I don't know the page number.
66. I looked it up today.
Okay, well done. The JCAM has a paragraph that pretty, in actually a great amount of detail, describes what's in the letter. Basically, it's a letter from us to the Postal Service in this case that says, we've concluded that this issue, involves an interpretive issue within the meaning of Article 15, Section 3 of the National Agreement. We'll give the facts. We'll give what we view the interpretive issue as. It defines the issue pretty well in that initial letter. And there's a reason that the parties are required to do that, so that it's clear what the issue is that we're identifying, so that we can move forward in the process with, it places some burden, at least in a prima facie sense, on the party that's initiating the dispute to describe the specific facts, describe what we believe the interpretive issue to be.
So now we sent the letter. What happens next? How do we get a conclusion on the interpretive dispute issue?
Yeah, so there's a process. It's outlined in the agreement. Once a dispute is initiated, the parties meet and discuss it and hopefully resolve it. If we're unable to resolve it, then there's an additional step where we provide letters to each other that lay out our factual positions. And then if it's not resolved after that, then it could be appealed to national arbitration. Over our history, the vast majority of these have been resolved through settlement. Those settlements have occurred at different points in the process. We've had some that have occurred reasonably soon after disputes were initiated. We have others, probably just being honest about it, more often than not, that have been resolved after cases have been scheduled for national arbitration. But every single issue is different. The circumstances around, an issue at any particular point in time are different. But the process is designed just like the process of informal A and formal A, and Step B is designed to resolve issues as soon as possible. So we make every effort in good faith to reach a resolution, of course, that fits our view of what the resolution of the issue would be. But, there are times where we've been unable to reach settlement, and that's what the national arbitration process is for.
When I was doing my research and talking to some of the staff in the building, the word abeyance came up, and I would just nod my head and pretend to know what I know what it meant. I don't. So could you let me know what the word abeyance means?
Yeah, the word abeyance actually appears in Article 15, Section 3F. When an interpretive issue is defined or initiated by either parties, grievances that are pending that involve that issue are held in abeyance pending the outcome of the interpretive issue. And abeyance just simply means to put something on pause pending some action. So, for example, we have an interpretive grievance here about an argument that management is making towards arbitrability and time limits. If that was an issue in a grievance that was appealed to arbitration, that grievance would not go forward to regional arbitration. It would be held pending the outcome of this interpretive issue. And then, of course, once the interpretive issue is adjudicated, whether by settlement or national arbitration, you would take that decision. The cases that were held in abeyance are then released, and you apply what the outcome of that interpretive dispute was and process those grievances accordingly. So abeyance just simply means placing on pause pending something else.
Thank you. All right, let's get into the particulars of these two particular interpretive disputes. First, let's talk about the arbitrability. Almost had it that time, pretty close, of grievances not resolved by a Step B team within 14 days. Can you explain what our Step B representatives do and what their work day or work week look like normally?
Sure. If it makes you feel better, I think arbitrability is a made up word. I think it's one of those words that grievance people made up a long time ago. Um, so step B is the step in our process where following step A, informal step A, which your shop steward, your supervisor meet on a grievance, goes to formal step A, which is the postmaster and the branch president or their designees. If they're unable to resolve the grievance, it is moved up to what we call step B. You might also hear these, their teams, you may hear them referred to as the dispute resolution teams. And these are teams that have one management and one union member. They work full time. Their job is to receive these grievances from a defined geographical area for the most part, take the grievances, read the grievances, and write a written decision to apply the contractual provisions that are relevant with the facts of that particular grievance and write a decision. So this is what they do every day. They do this for at least 40 hours a week. Most of them have a pretty significant workload, though it sort of ebbs and flows. But it's never a situation where they're sitting around looking for something to do. They are very, very busy all the time, and they can issue a variety of different types of decisions. And one of those decisions that they issue is when they can agree, and that's what's called an impasse, where both parties, the management and the union representative, write up their positions. That grievance goes to the NBA office and can then be appealed to arbitration. In an ideal circumstance, they are resolving grievances, so they write decisions. You get that grievance back locally, get that decision back locally that resolves your grievance.
Okay, so that's the way it's supposed to work. Say if the workload gets too heavy, can the Postal Service activate more teams to get this process running smoothly?
Yeah, there's a lot of different things that can be done. You mentioned activating teams. So each team, we have 60 something teams that work full time. This is what they do all the time. We also have backup representatives on both sides, management and union, that are trained to do this. A memo in our contract, the dispute resolution process memo, actually says that when cases have been at step B they should be resolved within 14 days. But when they've been there for more than 14 days, the party should consider activating backup teams. There's also other things we do. If one team has a really heavy caseload and there's another team somewhere else that doesn't have as heavy a caseload, sometimes we'll send some cases from over here to balance out the workload. But activating backups is a primary way that's actually mentioned in the contract to address circumstances where the team's workload gets a little too heavy to maintain their normal timelines.
Auxiliary help.
Yeah, exactly.
So on both sides, we have certified Step B reps ready to work, right?
We do, yeah. Now and then we might have a circumstance where we've got people that are trained that are on both sides that are no longer available for whatever reason. They've retired, or managers sometimes go take a different job, so they're no longer available. But it's something we do a pretty good job of ensuring that we keep people that are trained. So there are definitely isolated instances where we may not at a particular point in time have someone available, but by and large, we always have people available to serve as backups.
So what was the issue that the Postal Service brought up that made us issue this interpretive step dispute?
Yeah. So a lot of those folks out there, I know there's people listening to this that are arbitration advocates, will certainly understand it. There's also others listening to this that have probably been involved in arbitration. And the Postal Service, the easiest way out for them in any grievance is to raise some issue with process. And we talked about this word arbitrability. So very often the Postal Service will try to make an argument in arbitration that a grievance is procedurally defective because the union didn't do this or that. They didn't make their timelines, or they'll try to challenge something about who filed the grievance, that type thing. We saw a few months ago a management representative at Step B make an argument in a grievance that was going to be impassed, that was going to go to the National Business Agent's office, who would more than likely appeal it to arbitration, that because the dispute resolution process memo in our contract sets out an expectation that decisions received at Step B should be resolved within 14 days, in this particular case, these are grievances that have been placed on hold at Step B and then moved later, that because it had been more than 14 days since the grievance was received at Step B, that it was untimely. And therefore, they would argue that it was not arbitrable. And let me just talk about what that means when they say it's not arbitrable. They make silly arguments all the time about arbitrability. Our advocates are very well trained. They handle them. But what happens is if an arbitrator buys that and says it's not arbitrable, the grievance is dead. We don't even hear the merits of the grievance. The dispute resolution process, MOU, does indeed say grievances should be dealt with, resolved, held, impassed, remand. Those are the 4 types of decisions. Should be decisioned at Step B within 14 days. But it also very clearly recognizes that's not always going to be the case, because it talks about what to do when they're not decisioned within 14 days. The Postal Service, a Step B rep somewhere, every day is going to come up with some kind of goofy thing like this. And normally what happens is that type thing is elevated to the NBA. The NBAs, for the most part, resolve these issues. Sometimes they may come up to headquarters and we can address them on a case-by-case basis. That's sort of normal business. That happens all the time. This particular issue would be, you know what, that's ridiculous. You can't make that argument. Where it crossed for us into an interpretive issue of violating the dispute resolution process MOU is that this started to pop up in multiple locations. We saw this with one team. We then saw it with another team. We expect to see it with another team, which most of the time means it's a result of some instruction either from the area level or from the headquarters level, even potentially. And it is a joint process. There is significant differences between the responsibilities of the parties at formal Step A, for example, where a lot of you that are listening have handled cases at Formal A. You appeal the grievance to Formal A. Management's got so much time to meet with you and schedule a meeting. And if they don't, the union has a responsibility to move the case forward, right? To send it up to Step B to maintain our time limits. The union can't unilaterally move cases from Step B. I mean, this is all part of the process. So it's a really silly argument that the Postal Service is making, intended to, there's only reasonable conclusion. It's just intended to sabotage the process and clearly, violates in our view, violates the dispute resolution process MOU. So we think it's a really strong case. We initiated this grievance last week. So we will, here in the very near future, move forward with discussions with them and hopefully be able to resolve it in a way that's satisfactory and, eliminates this problem from the Step B process.
Okay. Can we just double down on that argument? Like what our argument is? Like, let's just get it like nice and clear. Like what is our argument that we're going to, our side of the dispute? Can you just repeat that for me, please?
Yeah, a little bit. I'm not going to get too deep into it because we haven't met with the Postal Service yet.
Sure.
But our argument in a nutshell here is the dispute resolution process memo recognizes that teams should resolve them within 14 days. That's a joint expectation. It's an expectation at a step of the process where every single thing is done jointly. And if the Postal Service's position of we can just say it's been there 14 days, therefore it's untimely, they could just sit there and not do anything for 14 days, then claim the grievance untimely. And often these interpretive issues come down to the intent of language. And when something was negotiated, what was it intended to mean? And very clearly there is a mountain of evidence, and could be through testimony, that the intent of the dispute resolution process at Step B is 14 days joint process. In fact, the memo even contemplates what to do if cases are not decision within 14 days. So basically, the argument that the position that they have taken here is just simply it's nonsensical. It is very much contrary to the intent of the MOU. And these are the kind of arguments that happen in interpretive cases. They're very rarely black and white, and we all like things to fit into nice little packages. But you're talking about what language means, and oftentimes that comes down to interpretation. And thankfully, on this particular issue, this is a process that we've had now for almost 25 years, and language in our contract that's been there, for a long time. So it's really easy for us to, I think, demonstrate that intent. And look, we're confident that we'll reach a positive outcome for us that'll eliminate this problem that is clearly just an attempt to throw a roadblock in the process of actually processing and resolving grievances.
All right. So now that we sent the letter to the Postal Service, what exactly happens next?
Yeah, we'll meet with them. Just lay out the facts, the issue, discuss it, try to reach resolution. If we're unable to do that in the initial meeting, we'll go through the process of exchanging, I guess you could call them position papers, or you often hear them called 15-day letters, and while continuing to try to resolve it. And if, it goes on for 60 days or so, and we're unable to resolve it, then, we'll likely appeal it to national arbitration.
So you'll lead the talks on our side. Who leads it on the Postal Service side?
It would be the president of the NALC and the vice president of labor relations. Very frequently, they're designees that talk about this. I know for our union, that kind of differs depending on the topic, but the primary person is normally the executive vice president. So Paul would do the majority of that. That's during the time, 6 years I was executive vice president. One of the primary things that I did. But with us now having multiple interpretive issues going on at one time, I'll talk to my counterpart over there, and we'll figure out who makes sense. Does it make sense to talk about both of them with the same people or with different people? So we kind of look at every situation differently. But for us, that's typically how it works. And for the Postal Service, it's ultimately it's going to be up to the vice president of labor relations, but normally they would designate the manager over the contract administration unit that deals with us.
So if we do have to go to arbitration, would it look like an arbitration that our arbitration advocates would be used to, or is there a different type of hearing?
Yeah, in some ways it looks the same. I mean, there's an arbitrator and there's an advocate on both sides. The hearings are in some ways even more informal. It basically witnesses can be called, and evidence submitted, and all that sort of stuff. And when we have witnesses, there's direct examination and cross examination, and redirect and all that stuff. But the hearing is really about both sides presenting the clear case that they believe they have. The arbitrators that do it, like the national arbitrator Dennis Nolan, is more than likely the arbitrator that would do this case for us. They have a wealth of experience, and depending on the issue, sometimes they have more familiarity with some issues than they do with others. They may have dealt with a similar issue with our union in the past. They may have dealt with it with a different union. So it's a rights arbitration. I would say it's most similar to, for those that are familiar with regional arbitration, it certainly is most similar to a contract case, where the party that initiated the interpretive dispute, just like in a contract case, the party that initiated the grievance, a union, has kind of the initial burden, and it proceeds from there. So in some ways it's similar, but in some ways it's different. It's a much more of a little more of a I guess, legal type proceeding in terms of the type of evidence that's presented. There's, never any sort of really productions and, fist banging on the table and stuff like that. It's more kind of, frankly, boring and nerdy type stuff.
No Matador outfits in this one.
Right. Yeah.
Yeah.
No Matlock pacing the room. Yeah.
Okay, so let's talk about NACI now. Can you give us a background on what NACI is and how it affects our members before we get into what the dispute is?
Yeah. So NACI, NACI, stands for National Agency Check with Inquiries. And let me just give Eddie, just to be sure everyone gets this, because it's kind of complicated, a background on what that is, leading up to an interpretive dispute that we had in the last year or so related to this, and how it led to the current interpretive dispute. So the Postal Service, whenever a letter carrier or any postal employee is hired, they do a security check or background check. Everybody listening to this that's a letter carrier is familiar with that, where you have to, get fingerprinted, and you go to the local law enforcement people, send something to the inspection service, and all that stuff. So that whole process it's called a National Agency Check with Inquiries. That's a name that comes from the rest of the federal government. Years ago, there were two separate levels. One was called the NACI, the National Agency Check with Inquiries, and there was another one called a SACI, SACI, a Special Agency Check with Inquiries. When someone was hired as a non-career employee, they went through the SACI. Then when they were converted to career, they went through the NACI. And I'm talking 10 plus years ago, kind of early on after the CCA category was established with a DOS award in 2013. So what happened is we had some people that when they were hired as a CCA, they would get a favorable result from the SACI. But then when they converted to career, they would run the NACI and it would be unfavorable. So we had a few disputes that are kind of similar to what we've been dealing with that arose then. There were not that many of them, so we were able to deal with them on an individual basis. And the Postal Service's solution, which was a wise solution, was instead of having two different ones, just do the NACI when someone's hired as a CCA initially, and then we don't have to do it again when they're converted. So that's what they started doing. That worked just fine for a number of years. Then, a few years ago, we ran into a problem where they just got slower and slower and slower with doing these NACIs. So we had circumstances where letter carriers, in our case, would get hired. They would start working. They would surpass the period of time where they did not have access to the grievance procedure, either 90 work days or 120 calendar days, whichever came first as a CCA, or their 90-day probation if they were hired as a PTF. And then after that, the results of their NACI would come back as unfavorable. And the Postal Service would separate them and say, you don't have access to the grievance procedure, that this NACI result supersedes your access, even though contractually at that point, because they had completed that 9120 or 90 days, they had access to the grievance procedure. So this became an interpretive dispute. And we initiated an interpretive dispute. The other postal unions initiated an interpretive dispute. And the case went to national arbitration I believe it was last fall. All the unions intervened in that case, and we were successful. The arbitrator issued an award that said, yes, these employees have access to the grievance procedure, which kind of takes us to the interpretive dispute now. So that is once that was done, what should have happened is then the Postal Service should have taken the cases that we had on hold when people had been separated, and just put those back in the grievance procedure with us and processed them, and they turn out the way they turn out. And unfortunately, that's not what happened. But let's be sure, Eddie, do you have any more questions about the NACI before we get into what this dispute is about?
So is it a postal service run program, or does someone else run it for the postal service?
It's a quasi postal service run program. The inspection service does part of it. So it's not completely within their control. It's actually very similar, if not exactly the same, to what a lot of other government employees do. So, there's efficiency is not exactly the federal government's forte, as we all know. Believe it or not, the Postal Service is kind of ahead of the curve in some ways, as hard to believe as that is. So, yeah, part of it's not within their control. Part of it's the inspection service, who the inspection service utilizes other resources, in the kind of law enforcement and the federal government world to produce the result.
And just to make sure I got it right, so before, or at least at one time, they're able to run that check prior to the 90-day time frame after a carrier makes career.
Yeah, we had no problem with this for a long time. And obviously, if somebody starts and they return an unfavorable result, and they decide this person can't continue to be a postal employee, and they're within that probationary period, they don't have access to the grievance procedure. So the Postal Service then could remove them or separate them, and they would not have access to the grievance procedure. We did not have any problem with this for years, and then I don't know the specific reasons why it slowed down, but it started to slow down a few years ago, which gave rise to this issue.
And can you just talk real quick about what, like, for maybe some of our newer members or newer listeners, why that 90-day, 120-day, window is important for our members?
Yeah. So when letter carriers are hired, contractually, if you're hired as a city care assistant for the first 90 work days or 120 calendar days, whichever comes first, you don't have access to the grievance procedure if you are disciplined or separated. That is consistent with the 90-day probationary period for those that are hired as career employees, which has been the case forever, basically, for at least decades in the modern era of our collective bargaining. And it's also pretty consistent with what we see throughout, the rest of the federal government. So it's really a period where it's probationary in nature, that the Postal Service gets to, make a decision really whether they want to maintain employees without them having access to the grievance procedure. But once they cross that threshold, they have access to it. And in order for the Postal Service to discipline or separate them, it's going to be subject to the provisions of our collective bargaining agreement.
Yeah, they have a steward by the side, and the union has their back. That's what we like to say here.
As Eddie always says.
Yeah. So we were talking about what the post office should have done, but what did they do when they received the award?
So when they received the award, we had grievances that were on hold, held in abeyance, as you asked earlier, for members who had access to grievance procedure but were separated. And then we filed a grievance saying you got to give them access. Well, what should have happened is those grievances should have immediately moved through the grievance process, because the arbitrator said, yes, you have access to the grievance procedure. What happened is the Postal Service in some locations just refused to schedule them for arbitration. And that's what gave rise to this interpretive dispute. Now, there's another piece of this. Number one, they refused to comply with the award by refusing to process these grievances with us. Number two, the Postal Service has sued in federal court to vacate the arbitration award, which they have a right to do. They're more than likely probably not going to be successful doing it, but they have a right to do it. They believe that the arbitration award, is inconsistent with the law in some form or fashion. But that does not mean that they can simply just refuse to comply with the award, which is what this interpretive dispute is. So the interpretive dispute here, the new one, is can the Postal Service suspend compliance with a national arbitration decision pending the outcome of a federal court proceeding to determine whether an arbitration award should be vacated? That's the interpretive decision. That's the interpretive issue here. And I think it's really important to point out that while this NALC case is the national award that gave rise to it, the interpretive issue here, it could be any national arbitration decision that they decide they want to sue and try to vacate. And what that means is they're saying it's inconsistent with the law, or the arbitrator by law didn't have the authority to issue the decision. So they're attempting to get the court to say that. But it could be any national arbitration decision. And of course, that's a very dangerous thing for us. And the reason that we initiated this case is if the Post Service had the right to do that, then all they'd have to do is go file suit in federal court, which is probably going to sit there for who knows how long. It's basically an excuse to never comply with a national arbitration decision. They could just say, oh, we filed suit in federal court to vacate it. So we feel very strongly about our position. The national arbitration is the end of the line in our process, in our collective bargaining agreement. And, once that is done, it's final, it's binding, they have to comply with it. If they then challenge it and they are successful, then we deal with that when we get to it. But that is, in the 15 years I've been at headquarters, that has not happened. And frankly, it's, I'm no lawyer, but I don't, we feel very strongly about, because this type issue has been litigated before, actually, a long time ago, but it's been litigated by our union before. We feel very strongly that the decision will likely not be vacated. But in any circumstance, once that arbitration decision is issued, they have an obligation to comply with it.
So them complying, is that going to go through the same process as our 14-day Step B decision dispute?
Process-wise, yes.
Okay.
So we'll discuss it really along the same timeline. It's something that, I certainly am hopeful that we'll be able to reach agreement on and spell this out in black and white, put this issue to bed. But that federal court case that they have sued to vacate the arbitration award is pending. So I'm sure that'll play a part in their mind as to, when they're ready to resolve it. But we'll definitely make our best effort. And if we're unable to resolve it, then, it'll go forward to national arbitration.
If it does go to national arbitration, will we get the same arbitrator, try to get a 2-for-1 deal, save some money?
I don't know if we'll save any money, but we probably will have the same arbitrator. Arbitrator Dennis Nolan is the only arbitrator we have on our national rights panel. We don't really have a need to have more than him. He is very well respected, and there's just, I don't think there's any scenario where, at least directly in front of us, where we could have a better arbitrator. So chances are he would do both cases. Normally when we do national arbitrations, they take, though neither of these are terribly complicated, they usually take at least a couple days each. So it'd be nice if we could be more efficient and save money, but I don't imagine that's what'll happen.
Okay, on these issues, is there anything that I missed or something that I didn't cover here?
No, it's a little bit of a kind of, I'm sure for the kind of contract nerds out there, you probably loved listening to this, and for others it might seem a little dry, but it's a really important piece, because think of it like this: we bargain a contract, and we've done actually a really good job the last several rounds in and I'm talking about us and the Postal Service, in when we agreed on something, making sure we have a mutual understanding of what it means. So we've had very little disputes that have arisen, but things happen all the time that just highlight issues. So you can almost view it as bringing parts language that's in the contract to life, sort of as an extension of collective bargaining. And it's very natural that there will be issues where we, at least on the surface, to begin with, won't agree, and it's a process for us to be able to resolve those disputes. And just stepping out and looking big picture, it's really important for us that we have this process, not just that we have collective bargaining, which is obviously important, but the ability to take any issue where we believe we have a difference of opinion in what language means, and have a process in place to ultimately, if necessary, have it decided by an arbitrator. So it's almost an extension or continuation of what we do every few years in collective bargaining. We've got a history as a union of being really successful doing this. If you go back through the MRS, you'll see a lot of memorandum of understanding. You'll also see an awful lot of national level grievance settlements through there. And every one of those settlements, many of which are just all across the JCAM and we utilize and read every single day, were reached as a result of this interpretive step in the grievance arbitration procedure. So I think we covered it pretty well. These two issues that we have in front of us are both very important. I think there's a pretty strong possibility that we're going to have another one in the near future. So I'm sure we'll talk about that one once it's initiated in future episodes, and probably pretty soon too.
Sounds good. So for our next segment in the podcast, we're going to do our second installment of a roundtable discussion with the rank and file committee members. And we actually recorded it last night, give you a little peek behind the curtain. It was a really good conversation. I hope you're going to enjoy it. Some of the same questions were asked, but we also had some different answers. So what do you think about the conversation you guys had?
Yeah, I thought it was great. I'm not sure if my voice was worse last night or today, but look, these folks that we had, Yvette and Eric and Mike and Juan, all did a great job the week they were here. Very much like everyone heard last week when we heard from the branch leaders. I think their perspective is really interesting, because in a lot of ways it's similar to what you heard from the branch leaders, but I thought there were some different things that came out that were really interesting. So just a great group of people. I think our listeners will really enjoy hearing from them. And it was a lot of fun for me to be able to kind of moderate their discussion.
Yeah. So for our listeners and viewers, let's watch this, and then we're going to come back and have a few Ask the Mailbag questions after that. So enjoy the segment.
Well, we're happy to be joined by 4 members of the Rank and File Bargaining Committee, specifically members of the group of contract enforcers. And to get things started, I will ask each of you to just briefly introduce yourself and tell us a little bit about where you're from. So Eric, let's start with you.
Well, hey, thanks, Brian. I'm Eric Porter. I'm from Sheboygan, Wisconsin. It's branch 102. We're kind of maybe a mid-size or smaller branch, about 130 members. We have 3 different separate installations that we represent in Sheboygan, Sheboygan Falls, and Kiel. And those range from anywhere from a little office like Kiel, it's got 2 routes, to Sheboygan with 43 city routes, and then we got a handful of rural and clerks and all that jazz as well. I'm branch vice president and chief steward, and currently activated as a backup DRT member.
Cool. Thanks, Eric. Yvette?
Hi, Brian. So my name is Yvette Kinard. I'm from branch 36, a fairly big branch. We cover about almost 5,000 members, about 70 stations. I'm I'm currently a part-time officer. I'm the editor of the Outlook for the paper, and I'm also a primary DRT member.
Thank you. All right, Mike.
My name is Mike Ridgely. I'm a letter carrier from Silver Spring, Maryland, branch 2611. What's up, Aspen Hill? We have 6 stations in Silver Spring, no SNDCs or anything, about 350 active carriers, big and small stations. Got hired as a CCA in 2013 in Seattle, transferred out to Maryland in 2016, and I'm a shop steward, a Formal A, and the OWCP rep for Silver Spring.
Thanks, Mike. Welcome. Juan?
Hello, everybody. My name is Juan Munoz. I am the president of the Padre Island branch 1259. We cover Corpus Christi, Texas, and about 12 surrounding coastal cities. About 330 active members and another 120 retired. So nice sized branch. Handle most of the Formal A's, and then also backup DRT, arbitration advocate. Actually heading out tomorrow to go handle a case. So, but just holding down the fort.
Great. Well, thank you all for joining us. I know we've talked on previous episodes about how this 30 person group, this rank and file committee, was incredibly diverse, in particular with the perspectives that each brought to the table, coming from big cities and suburban areas and what we would call smaller towns, and from very large offices to very small offices. And, you know, even among the 4 of you, all that has been represented. You all did excellent work the week that you were here, but I want to kind of start before we get into the week itself with kind of what was on your mind or what you were thinking before the week. So we, you know, admittedly didn't provide a ton of information about what you would be doing when you got there, but I'm curious if you can think back to after you were contacted and you know, you were confirmed your availability and we scheduled your travel and all that sort of stuff. Kind of what were your expectations coming into the week? And Mike, why don't we start with you?
Sure. Like you said, we didn't get a whole lot of info ahead of time, other than that National was seeking input on what should try to be negotiated in the next contract. So I didn't have a whole lot of expectations. I expected some good debate, discussions, and I was excited to provide a perspective from the workroom floor to best help our members in today's postal service.
So you traveled in on a Sunday. Each of you got there, and we began that Sunday night. As I recall, I think it was about 6 o'clock, and just kind of welcomed everybody. And then I came out there to, in a sort of general high level sense, explain what we were doing there. So if you think back to that Sunday night, I know I dumped a whole lot of information on you in a pretty short period of time. What's your recollection of the things that we discussed? Was there anything you learned on that first night, or what's your memories of that time? Yvette?
So I remember you talking about the pie. That was the biggest part. Pretty much that, you know, we can ask for a whole lot, but what are you willing to give up to get those things? I want to say that the history probably was the biggest part for me, like knowing, you know, what we asked for in the past, just kind of how we got to where we are now.
Yeah, we really thought that was important to kind of lay the foundation for the work that was done throughout the week, which we'll talk in depth about that here in just a few minutes. So Monday morning began with a general session with all 30 people there to kind of discuss the structure and what you would actually be doing. I guess you could say the mechanics of how this would work throughout the week. So Eric, why don't we start with you, and why don't you just tell the listeners about the way things were laid out that Monday morning, as far as what would happen over the course of Monday afternoon, Tuesday, Wednesday, and kind of the way things were structured.
Yeah. So it was a great opportunity to finally really wrap our heads around what we were being asked to do and what kind of was going to be delivered at the end of the week. And so that was when really learned about, okay, we're going to mirror the subcommittees that exist at the national level for considering various components of the national agreement. We figured out which subcommittees each of our committees was going to tackle, and then got kind of that structure that we were going to come up with some ideas. We were going to look at the existing materials out there. Resolutions have been passed since 1970, the other postal union agreements and their recent changes, and using all of that along with our perspectives from our home branches and various union duties, kind of come up with what are the thoughts of where the priorities lie and where are the opportunity areas, or what problems need to be addressed that our members are dealing with. And then, you know, also that we were going to have to operate our committees ourselves. We were going to need to figure out how to work together and how to bring our diverse perspectives into a cohesive and coherent narrative to share up to the exec council.
Yeah, I think you mentioned something really important there that we've talked about on the podcast before, and that is that one of the basic, I guess, sort of foundational ideas of what we wanted to happen over the course of this week is in a lot of ways to get rank and file members like you all, rank and file in the sense that not executive council members, to mirror the work that the executive council bargaining subcommittees were doing. Now, of course, that had to happen in a very compressed period of time where we took 10 people and put them together on a topic. And Eric, as you mentioned, the work had to be done by those 10 people. So there had to be some structure to it. One, I know each committee of 10, maybe this changed from topic to topic, but the structure that was put in place to facilitate the discussion was there was a chair, there was a secretary to record information. Why don't you tell the listeners about what that structure was like and how that kind of played out in your group, those different roles in the discussions?
Yeah, and so those subcommittees that the exec council is part of that we were mirroring were, you know, covering different chunks of the contract, like our national agreement articles 15, 5, 17, and 31. And so for that topic cluster, we would, in our group, we assigned one chair, one secretary, and we basically just let everybody volunteer themselves. And so each of us grabbed one of those roles for one of the subcommittees. And like for that instance, Yvette stepped up, first person to be chair, and I was glad to be her secretary. And then as we moved through the week, we just rotated through which committee we were discussing and who was chair. And the secretary role got a little bit less clear, or didn't hand off as much, but it was pretty much a very natural flow, and everybody worked, I think, really well together, sort of sharing the load of what those two roles are meant to cover.
So Juan, when we think back to those discussions are taking place, you know, whether it's Monday afternoon or Tuesday, Wednesday, Thursday morning even, how did they go generally? Were there disagreements? Of course, we got different perspectives that come together. Just give us a sense of how those discussions played out.
I see Mike shaking his head. No, it was very interesting. Initially, the first Monday, Tuesday, Wednesday, we were pretty on spot with the topics. There were some discussions, you know, about how it doesn't really affect certain branches, but nothing really we weren't too far apart on any of the differences. Once Thursday rolled around, which was more of the economic portion, that's where, you know, differences of opinion started coming out, and it was healthy. I mean, there was no, you know, yelling or, you know, trying to talk over each other. Everybody got a chance to speak, and, you know, we all stated our perspectives, and then in the end, we were able to kind of, you know, come to some sort of conclusion and put out the report. But no, it was It was great. Great discussion amongst all the topics because sometimes, like I said, it doesn't affect one branch, but it's completely out of control in another branch. So we were able to actually see that across the board.
Excellent. So, Mike, I'll go to you for this one. Let's dig in a little bit about, just for the listeners. So this discussion takes place and you know, different perspectives, as Juan mentioned, come to the table, and eventually the group settles on what are the priorities, what are the things on this particular topic we should seek to achieve. Why don't you tell us about, I know you were not the secretary necessarily, but how did those ideas or words that were discussed and what was on people's minds actually end up in a document and put together in a structured way that it could be utilized? Why don't you tell us a little bit about that?
Sure. So after debate and discussions, we decided on an idea, then we put it in writing. Eric, our secretary, wrote up our idea on our idea forms. I don't know if it was more he volunteered or was kind of voluntold by the group, but he basically was elected the secretary for the whole group. I mean, he did a great job. So, hats off to you, Eric. But the chair would write up a report about each article that was discussed that they were responsible for. And the secretary would write up minutes. And it was pretty handy in Microsoft Teams. We were able to go in and double check accuracy for stuff. We actually put some stuff up on the projector too, so everyone could talk about it at once. So I feel like it was a pretty smooth process in terms of, being able to double check everything, that was talked about was good in writing.
Yeah, which is a very important piece of this is, being able to document and compile all of the input and the feedback that was given by the different groups on so many different topics throughout the week, so that it's in a really usable form. Yvette, we had a handful of our letter carrier staffers from headquarters. Doug Lape, who you've heard from on a previous episode of the podcast on this topic, Tim McKay, Michelle McQuality, and Chris Henwood, who were there throughout the week. And each of them, they had a specific role. Why don't you tell us a little bit about what they did and then maybe what they did not do? I know they were there to serve as a resource. Eric, I think, mentioned earlier the bargaining resolutions, our official bargaining positions from conventions, and then we have the other unions' contracts and previous proposals that have been submitted and so on and so forth. They provided that information, but tell us about what their role was.
So Doug was great. I have to start off with saying that. Doug Lape was really good. For the most part, he left us to our own devices. He let us handle everything that we needed to handle. But he was the go-to person when we had like questions about history, or was certain things like resolutions actually presented before in collective bargaining? Was it presented to the post office, and kind of why it didn't get in, or possibly why it didn't make it too far? He also gave us guidance as far as things that may work for one branch or one particular article may actually change something in another area of the contract, or actually affect somebody's LMOU, which was, I think, an idea that we probably didn't think about initially when we were discussing certain articles. But for the most part, he left us alone. And so we had a question, or, he would chime in and just kind of say, interesting idea, or, something like that. But other than that, all around, he was great and left us alone to handle it.
Very good. So Monday afternoon, Tuesday, Wednesday, each group, including you guys' group, would spend 2-3 hours on a topic and then move to another topic. And this was a really fast-paced environment. But Yvette mentioned earlier I was out there on Sunday night, part of what we talked about is how the economic piece of collective bargaining works. And we certainly wanted to utilize the rank and file committees, the 3 different committees, to give input on priorities. And one of the things that I really stressed, and I think everyone understood, I know they understood based on what we heard on Thursday afternoon, which we'll talk about in a minute, is the idea that the exercise is really not to determine the things that basically all members of our union would agree we should try to achieve. Those are in our official bargaining positions. We all know what they are. They're all career workforce. They're higher starting pay, higher pay in the middle of the pay table, higher top pay, 100% COLA at each step. It's not a deep thought process to determine what those items are. The key really is the prioritization of them as negotiations play out. So I was really excited about each of your committees being able to sit down and talk through that prioritization. And Juan, I'll go to you for this one. Why don't you just describe a little bit about how that discussion went on Thursday morning within the group of contract enforcers? I'm sure, like the other groups, different perspectives brought different priorities to the table.
Yeah, so we started Thursday morning actually thinking we were ahead of schedule with the other articles. So he said we're going to be in and out and be done early. Lo and behold, we started talking, and the one thing about our group is, you have a lot of senior carriers that have been involved for a long time in contract enforcement. So by natural course, there's senior carriers more towards the top of the list, top of the table. And then we had a couple of people down in the middle of the table. And that's where, the actual issues came up and talked about how, we've got something for the bottom of the table, got something for the top of the table, and how the carriers in the middle, as the term or the saying's been going around, they got screwed. So there was discussion about that. What ideas could we come up with to somehow, get everybody something? So that was a big part of the discussion that, we thought we were in and out, and now we spent quite a long time on that issue. So yeah, we were able to see where they're coming from, the specific carriers in that middle range, why they felt that way, rather than just we got screwed. No, here's how they explained it out to us. So we were able to better comprehend, what was going on.
Yeah, so each of the three committees, the newer members, you guys committee, the contract enforcers, and the branch officers, branch leaders, went through this same exercise on Thursday morning. And then Thursday afternoon, we all got together in a group of 30. And I assume you guys were like the other two and that you were really eager to hear what the other two committees had come up with on their topic. So, Eric, why don't you tell us just a little bit about looking forward to having that discussion, and was there anything that that you heard as far as priorities and that type thing from either of the other two committees that surprised you?
There were some great ideas around discipline and how discipline should be handled, and how to either better involve the union or make that process a little more transparent, particularly around issuing discipline, which I thought was interesting. One of the things that really stood out to me, though, was how much overlap we had, and how some of that was not necessarily the bigger ticket economic items, but concerns around, equity amongst carriers of different, backgrounds and demographic characteristics, around things like people generally around the nation now have a lot more to carry, particularly, when you think about aging parents or young children. And so a real emphasis on dependent care, bereavement leave, and recognizing the burdens that people have to lift up at specific moments in their life, and trying to push that ball forward, along with, paid parental leave. Those kind of things sounded really, it was interesting to see how much uniformity there was across the three groups in terms of wanting to see those things addressed.
Yeah, I was really impressed in particular on the, let's call it the prioritization of the economic pieces, how there were, of course, people in the room that very passionately stated their priorities, whether that's someone, early in the pay scale, they're going to be, more concerned about that part of the pay scale, or those that are at the top of the pay scale, while at the same time being able to understand the entire exercise and the need to negotiate things that benefit all of our members to the extent we possibly can. Mike, was there anything that stood out to you Thursday afternoon when the discussion was sort of back and forth between the three committees on the economic priorities?
Yeah, I mean, we got a really good group of people that are obviously in it for the right reasons. We all want to get more for our members, to improve their quality of life, financially and stuff. But it was interesting seeing the passions come out. Like, that was the most heated debates I saw all week, were about, the economic priorities. And people from different backgrounds, newer carriers, older carriers, they're going to have a different view on it. So it was really interesting to hear not only what their priorities were, but like the reasoning behind it, which, a lot of times we kind of just look at it from our own perspective, but to hear, the explanation from other other people different from us really, I feel like, opened a lot of people's eyes.
Yeah, Yvette, just to wrap up this topic of what we did out there on Thursday afternoon, back and forth between the committees, I know that kind of passionate discussion about the economic priorities. Was there anything in particular to you that that stood out that would be interesting to share with the listeners?
I want to say what surprised me was the newer members, the things that they were willing to give up to ensure like longevity. I thought I was really impressed by it. And definitely speaking with Mike, how passionate he was about the carriers within the middle, and he kind of changed my perspective on it. I kind of went into it thinking, kind of one way, like, okay, you definitely need like higher pay at the end. And then when he kind of explains about how like those CCAs in the middle that are now have like 10 years in, 11 years in, how they kind of got squeezed out, and how they want to, feel like they kind of got back their time. And so by the time he finished explaining everything, I was 100% on board with him. And so I was impressed with him and the newer members. The newer members really impressed me.
Yeah, what went through my mind when I was listening to the newer members is I 100% agree about their ability to think long term, as opposed to just addressing what they view as an issue right now. For example, if take the all career workforce model, which everyone's in favor of, but it results in, say, a conversion to career 6 months quicker than it otherwise would have happened for existing letter carriers, their CCAs. And that certainly has an economic benefit to them versus something that happens at Top Step, where they are going to probably spend 2/3 of their career and their retirement. And to me, it really illustrated why, when you look at the history of our union, we are hearing from newer members that bring that perspective, that have the ability to look long term, which very clearly demonstrates why in the history of our union, we have always taken a very long-term approach to collective bargaining, our entire economic structure. And it was really, I guess, energizing to me to see that group, come in and think that way. Because it's important, when this job over the years has been through collective bargaining, has been a job that people spend a career doing. And that's really one of the main reasons why. So I have two more questions. And for these two questions, we are going to ask each of you to answer. So for this one, Juan, I'll start with you, and then we'll go around the horn here. I just want to give your overall view of the week that you spent together. What were your kind of takeaways, and do you, what did you learn about the collective bargaining process? Just overall, how do you feel about the way the week went? Juan?
It's a lot different than most trainings that we go through with NALC, where, were crunched for time and working late into the night on projects. So this was kind of a little relief. It was, it wasn't as with a heavy hand. So, we had time limits, but we also had, hey, at 5 o'clock, cut it and go home. So that was one of the differences that was kind of better overall. But then again, like I said, going through the week, everybody worked on the same articles, just with different membership groups. And yeah, when it came around Thursday, when everybody got to see everybody's ideas, we saw who was on the same page, who was on a different page, but more important, why. And like Yvette said, we got to see why they were thinking that way. And it was encouraging to see that, like I said, that the members we thought were going to be more focused on money were kind of focused, like I said, in the longevity of the contract. There's still some that had, that held on to the, we need something now. But again, everybody respected everybody's ideas. Nobody, to call them dumb. We talked about it. So that was a good thing. And then on Thursday, once we all actually, put the ideas, we put our top tens. Our top tens, pretty much mirrored themselves. So it's good that we were able to, being separate yet still kind of thinking on the same page, trying to get to the same end goals. So that was good.
Absolutely. Eric, what about you?
One of the things that really stood out to me from the week is how well the group worked together. Sometimes it can be challenging when you get a lot of, very experienced, very strongly opinionated folks in one room, and particularly those of us that deal with enforcing the contract. We have some pretty well developed ideas, let's say, and yeah, to have that still be a very productive conversation. It didn't bog down in repetitive arguments or get stuck too nitty gritty. Like there can be that push to really dive into the very fine level details, and yet I think the group did a great job of keeping coming back and finding the common ground or the core issue that we wanted to see addressed. And then too, that not having had a great understanding of what we were going to be getting into for the week, that once we knew what was in front of us, the way that we organized the work, prioritized the work, and then got it done, so that we had what felt to me like a really useful product at the end of the week. Where sometimes when there is so much emphasis on just conversation, it can feel like you spin your wheels and don't make it anywhere. And yet our group and the larger committee, I feel like, really put forward some meaningful ideas that will hopefully shape and guide bargaining in a way that hits that important component of not just getting a good benefit for our members, but something that they feel the benefit of. So when we talk about the people at the different stages in the pay table, or wherever, different size branches, different parts of the country, that not only do they get something positive, but then hopefully they feel that positive benefit.
Well said. Mike, what was your overall view of the week?
Well, like Eric said, we worked really well together. I feel like this work that we did will provide a really valuable, fresh perspective on like issues our members are facing on the workroom floor today. Along with hopefully giving the bargaining team like a head start, before they get to that table. This is kind of what the membership has been wanting, and the NALC made it happen. So I was really happy to be a part of it. Negotiating contract, it's not as simple as some people online would have you believe. It's hard choices are going to have to be made. We're not going to get everything, and this week really, we nailed down and, made some of those hard choices. And I think it was really valuable. I hope it's taken it, to heart by the bargaining team. And Also, I was really excited to hear you're bringing in another group of people in January for another set of fresh thoughts. So I think it's a really valuable week for us and for the whole membership.
Thanks, Mike. Yeah, we got another group in January. We'll talk about them in just a second. So, Yvette, what's your recollection or takeaways from the week?
So the guys pretty much said everything I was gonna say. um, for the most part, I believe that the week was eye-opening. I learned a lot. It was great working with everyone, the entire 30, well, 29 plus me. For the most part, coming in on that Monday, not really knowing what to expect. We were tasked with, breaking up into the articles and kind of coming with our own perspectives. I wanted to tackle 15. That was like one of my biggest things being on DRT. But hearing like the different perspectives from everyone throughout the week, it just, it opened my eyes to the issues that everyone is facing across the country. And it's not just about whether, issues in the bigger branches. You have to make sure that those smaller branches are also heard, and everything that you are deciding on or ideas that you have it has to be positive to everyone. And all around, it was a great week. And, like I said, the guys were great working with them. The collective bargaining was, contract enforcement was great,
Well, thanks, Yvette. So one last question, and Mike, you mentioned this just a minute ago. We are planning to have another group, a different group of 30 rank and file members come in to go through basically the same exercise, just to gain even more perspective. That likely is going to happen in early January. I know you all certainly wish them the best, and but probably, even though you don't know who they are yet, are not willing to concede your spot is the better of the two. But for the group that comes in January, which will be 30 different people, what advice would you give for them? So let's go to each of you. And Yvette, we'll start with you since you were last on the last one.
My advice would be to come in with an open mind. Do your research, just kind of organize your thoughts before you go in. Have ideas about what you would like to see, and just listen to different people's perspectives when you get there, and move forward.
Excellent. All right, Mike, what would your advice be to the group in January?
I would say get ready to work. Our brothers and sisters are counting on you to be their voice. And one of the most important things our union does, negotiating a contract. Don't be shy. Don't hold back because people disagree with you. Debate's valuable. You're here for a reason. Someone saw something in you and your mind, that you're going to bring to the table. So share your perspective, be thoughtful, keep an open mind. Yeah.
Excellent. Eric, what advice would you have for the group that's coming in January?
I would ask that you pay attention to those group dynamics and recognize the opportunities to either step up or step back. Some folks are really naturally outspoken. Some folks need a little bit more of an opening and conversation before they feel comfortable bringing their ideas forward. Both individuals have a lot to bring, and it can be easy to let the louder voices and more consistent contributors dominate conversation. So be willing to push outside of your comfort zone. If you're really big at adding your perspective, step it back a little bit. If you usually wait for that 5-second stop in conversation, you might not say a word the whole week. There are some people who are going to just fill that void. So push yourself whichever direction you need to go so that we're hearing everyone.
Interesting. That's really good advice. All right. Finally, Juan, we'll end with you. What's your advice to the second rank and file bargaining committee that'll come in January?
Well, no matter what committee or which group you're in, find yourself an excellent secretary like Eric. We definitely could not have done it. Like I said, each committee had their own secretary, and then somehow we ended up voting Eric. Eric ended up doing most of the minutes, but everybody was taking notes. So that's one important piece. But more important, like I said, we were kind of walked in there blind. Now that this second group is going to come in, they have a little more time to like Yvette said, do some research. Look at your, at your branch, the composition of the membership in your branch. LMOUs, like you said, that's stuff we never even realized that certain language would end up affecting LMOUs in a lot of branches. So the research is very important. So like I said, they have a little bit more time to do that research. If they get enough time, poll your members on what's important, and then they'll be able to kind of bring more of the branch voice into it than we were able to kind of last minute. So, but yeah, listen to the membership.
That's the key for sure. Well, on behalf of all our members, thanks to all four of you for the work that you did during that week. You all, I know the other 6 in your group were outstanding as well, but you all did a great job. And thanks so much for joining us. We really appreciative of you to take some time and come on the podcast and talk about what transpired during that week. And certainly that week was a week chock full of work, and there's a lot of work to be done. So that'll continue into the future. Thank you, guys.
All right, so here's our Ask the Mailbag segment. We have James Blackford from Branch 38. He wants to know if he's supposed to get back pay. He's not sure. He's been retired since July 1st, 2023, after 35 years of service. God bless you. I hope you get him for 35 years of retirement. So does he entitled to back pay, Brian?
Well, first, congratulations on your retirement. He retired in 2023. He's if you're like any of the other, 100,000 retired letter carriers I've talked to, I've not yet talked to one that regretted it. If you retired July 1st, 2023, you would not be eligible for any back pay because the beginning of the back pay period was in August of 2023 for the second COLA of 2023. So when you retired, your pay reflected the final pay increase of the 2019 agreement, which happened in March of 2023.
Okay. Our next question comes from Eve Woodward. She's from Branch 56 in Grand Rapids, Michigan. Is the government shutdown going to affect Social Security for FERS retirees?
Good question, Eve. No, it does not directly. The shutdown, as we're recording this, is ongoing. The one thing that we will have to keep a very close eye on following this shutdown once it's over is this whole budget process, where this budget reconciliation, as we dealt with over most of 2025, what turned into the one big beautiful bill. A lot of our retirement benefits were kind of put on the chopping block at that point in time, and we made it through that. And just as sure as, Congress, when they start dealing with this again, it'll be a topic of conversation. But we have to be very mindful of it in this budget process, but the shutdown itself does not directly affect Social Security benefits or any other benefits related to our FERS retirement.
Andrew Lopez from Branch 24 in Los Angeles wants to know, what date in 2026 does the current contract expire?
It expires on May the 22nd of 2026. We are going to officially open collective bargaining with the Postal Service on February 25th. So around about 3 months prior to that. And as we've talked about on previous episodes, and we'll continue to talk about, we got a lot of work to continue and to do between now and then.
And just to make it clear, when that contract expires, we're still under those guidelines, correct?
Yeah, if we're unable to reach an agreement by its expiration, which has been the case in every round of collective bargaining we've ever had except for one, the parties, there's a the federal law mandates a 60-day mediation period after that, which it's basically, inferred that the provisions of the agreement will continue. They all continue. If you read the agreement, every single thing in it continues. So, if we're unable to reach agreement, which history tells us, it's probably pretty unlikely, just being honest about it, that we will by May 22nd, then the provisions of the current agreement would continue until that successor agreement is reached.
The final question actually came from my state convention, and it was from Ted Lee. He's the branch president of 84 in Pittsburgh, Pennsylvania. He wants to know, is there a start date and an end date to put in for the leave buyback program? And how do you request it?
Yeah, good question. Yeah, Teddy asked me this, and I got a Branch 84 shirt on, I just noticed. Asked me this at the convention this past weekend. And actually, since we got back from the convention, we have been dealing with this a little bit with the Postal Service. So I have kind of an update over those of you that were in Pennsylvania, what you heard me answer Ted's question there. The Postal Service is going to send everyone that's eligible a letter that outlines exactly what the process will be. Postalese is, we think, going to be the primary vehicle to go in and, initiate the cash back, but everyone that's eligible, and to be eligible, you got to carry over 520 hours and have used 75 hours or less sick leave in this past leave year. But as far as the time frames, the only contractually, there really isn't a time frame. What's in our MOU, which mirrors what the other unions have, and what's already in a process that already exists for them, is basically that before the end of the leave year you'll be able to do this. So there's no contractually dictated time frame. But I'm sure those that wish to do this, once you get that letter and it's got the instructions, I'd suspect that most people will if they want to do this, will go ahead and take action there pretty quickly. So, as soon as they finalize that and the letter goes out, we're working right now on a post for the website and social media and that sort of stuff. That's kind of the reason that we reached out to them, is to take as much of the information that'll be provided in this letter and make it available so that shop stewards and branch leaders have it so they can assist their members, being it's the first time we've had it.
Okay. So that's the Ask the Mailbag segment. If you have a question you want to ask President Renfro, send them in an email to social@nalc.org. Bri, I want to thank you for your time as always, and have a good night.
Thank you, Eddie. Great job as always. This is a kind of information-packed episode, but I think our listeners hopefully will enjoy. I know they'll enjoy hearing from the rank and file members, and look forward to being back next week.
Yeah. See you next week. Thank you for listening to this episode of the Fight Like Hell podcast. Please subscribe so you don't miss an episode. And please share this podcast with your NALC brothers and sisters. You can follow the NALC on social media using Facebook, X, and Instagram. You can find links to our accounts in the episode description. May your steward be by your side, and may the union have your back. Thanks for listening. See you soon.